Hello, I'm Robin Henry, a partner at Collier Bristow and head of our dispute resolution team, which specialises in banking and finance law. Today, I'm with my associate, Jean-Martin Louw. Jean, would you like to introduce yourself?
Yes, thanks, Robin. Hi, I'm Jean-Martin Louw. I'm an associate with Robin in our disputes team, and I largely focus on banking and financial disputes. And today we want to talk to you about push payment fraud, the Quincecare duty, and how those concepts interact. So, Robin, what is push payment fraud?
So, the reason for talking about authorised push payment fraud, otherwise known as APP, is because it is the largest class of payment fraud in the UK. It's really common. It occurs when an account holder is deceived into thinking that they have transferred funds to a legitimate payee, like one of their usual suppliers or somebody else that they're familiar with. But in actual fact, the destination account is controlled by a fraudster. The funds are usually dissipated upon receipt into the fraudster's account, making them very difficult to track down and recover. And because it's pretty much impossible to track down the fraudster and recover the money, victims really only have one alternative, and that's to try to get compensation from the banks involved in the transaction, either their own bank, the sending bank, or the recipient bank used by the fraudster. So what we're going to discuss is what victims can do when they're caught by one of these scams. But to start, we should just talk a little bit about the Quincecare duty, how that fits in with push payment fraud, and a very important case involving Barclays, in which judgment was handed down at the end of last year.
Robin, can you tell us a little bit about the Quincecare duty and what exactly it is?
Sure. Now, to do this, we need to go back to first principles. Banks have a contractual duty to their customers to carry out those customers' instructions. If the bank didn't do so, it would be in breach of its duty to the customer. Where a customer has money in their account and the customer says, "Make this payment, please," the bank must follow their instructions. There's no discretion or choice. The bank just has to do as it's told. Now, there are some very limited exceptions. For example, if the payment would be unlawful, for example, if it's would be money laundering, but generally the bank has to do what it's told, and if it fails to do so, they could be liable for the customer's resultant losses. The bank doesn't need to concern itself with the customer's decision-making or why they're making a payment, and they don't need to second-guess the customer's decisions. However, there has been a long-standing exception to that general principle, and that's called the Quincecare duty. And this says a bank has a duty not to execute a customer's instruction where the bank has reasonable grounds for believing that the instruction is an attempt to steal the customer's funds. Now, in previous court cases, this has been limited to situations where the fraud is being perpetrated by an agent of the customer on the customer itself. So, for example, you've got a situation where a director of the company is intending to defraud the company and instructs the company's bank to transfer funds to his own personal account. If the bank is or ought to be aware of that fraud, it has a duty to its customer not to proceed with the instruction. And that's the Quincecare duty. Now, that's a different situation from that of push payment frauds, where there's no suggestion that the instruction by the customer is fraudulent. The customer wants to make the transfer. The question is whether the bank is under a duty, if it should be aware that a third party is attempting a fraud, to stop that transaction going ahead. But because there is such an epidemic of push payment fraud at the moment, it's clearly an important question for the courts to have considered, is whether the Quincecare duty could be expanded to include push payment fraud. And so that brings us to the case of Philipp and Barclays.
Yeah, and so what happened in that case?
Well, what happened was the claimant was a Mrs. Philipp, and she was the victim of a push payment fraud. She was tricked by fraudsters who were posing as officers of the National Crime Agency and the FCA. They tricked her into making a payment of £700,000 of her own money to an account in the UAE. The payment was made in 2 tranches, and each time she made the transfer, she attended a branch of Barclays in person, gave instructions for the transfers to be made. When she later discovered that it was all a fraud, she brought a claim against Barclays, alleging that it had breached its Quincecare duty, essentially because the bank hadn't put policies and procedures in place to detect and prevent this type of fraud. Now, obviously, Barclays challenged that argument. They said that the Quincecare duty doesn't apply in these situations. It only applies where the attempted theft was by an agent of the customer, not where the customer had themselves told the bank to make a transfer of funds. So at first instance, the court ruled in favour of Barclays and said, no, the Quincecare duty doesn't apply to push payment fraud. It then went to appeal, where it was held that the Quincecare duty did require banks to make inquiries in suspicious circumstances where they're put on notice of any potential fraud and then refrain from acting on a payment instruction in the meantime. So this was the first time that the Court of Appeal had actually held that the duty didn't depend on a bank being instructed by an agent of the bank's customer. It could be the customer themselves who instructed the payment in question. And that really expanded the potential application of the Quincecare duty. And that gave victims of push payment fraud some hope. But Barclays appealed to the Supreme Court, and the Supreme Court reversed the decision. And the reasoning is quite interesting. It goes right back to the first principles I mentioned earlier, the bank's primary obligation to comply with its customers' instruction to pay. And what the Supreme Court did was it clarified what the legal justification is for the Quincecare duty. It said that where the customer's agent is trying to defraud the customer, it's not some special duty at all, but it's a situation where the agent, as a matter of general principle, has no authority to issue the instruction because it's for a fraudulent purpose. In that case, the bank will be protected if it complies with the instruction only if the agent had apparent authority. However, and I apologize if we get a little bit technical here, if the bank's on notice that the agent does not have actual authority, it will be liable if it proceeds with the transaction, unless it has made inquiries as to whether or not the agent did have authority. So that's looking at a clarification of the existing duty, the limited duty where you're looking at a fraud by an agent of the customer. What the court was saying was the Quincecare duty is only ever going to apply in circumstances where the payment instruction is given to the bank by someone else who's acting as the customer's agent, and they're acting to defraud the customer. So if a customer themselves instructs the bank to do something, Quincecare just doesn't come into play. The fact that the customer has been induced by fraud to make the payment instruction is just not relevant.
Is it all over for victims of push payment fraud then? Do they have any hope of making recoveries from their banks?
I don't think it's all over. And I don't think the Barclays case necessarily was as definitive as that for victims, because the court held that the bank's duty of care to its customer is one which requires them to carry out their banking service with reasonable care and skill. And that's implied into the banking contract. It did say that duty is subordinate to the bank's primary duty, which is to execute the customer's instructions. The situation we've got is the bank is under an obligation to comply with the customer's instruction, but it is subject to its duty to do so with a reasonable degree of skill and care. Now, the court declined to lay down any general principles for what it meant for there to be the bank acting with reasonable skill and care. But it did say that the bank would at least have to have information which was not known at the time to the customer that a fraud was being committed, and that then proceeded with the transaction nonetheless. Now, in the Philipp case, the customer had been made aware of the likely fraud by the police. They had said that it was likely that she was being defrauded, but she had still wanted to proceed nonetheless. It was only later when the bank tipped off the bank and told the bank that there was a likely fraud that the bank refused to make any more transfers. It was only at that point that the court thought that the bank's duty of care could arise. So, on different facts from the Philipp case, it may therefore still be possible that where banks do not act with reasonable care and skill, where they are negligent, they will be liable to victims of APP fraud.
If what we're calling the Quincecare route is a dead end and a bank's liability for negligence is somewhat uncertain, what other hope is there for victims of push payment fraud? How can they recover?
Well, at the moment, victims are stuck with trying to get compensation from the banks, either voluntarily or through a complaint to the Financial Ombudsman Service. Now, most high street banks are signed up to a voluntary code which offers some protection for consumers who suffer at the hands of APP fraudsters. Providing that the destination account is in the UK and the customer has not acted negligently, they're usually entitled to be reimbursed by their bank if it is a signatory to that code. But if a victim's bank refuses to refund them for any reason, the customer can complain to the Financial Ombudsman Service. They will then investigate the circumstances and can order the bank to pay compensation of up to £415,000 if the customer has been treated unfairly. Now, there are actually some recently announced legislative reforms around compensating victims of push payment fraud. It will soon be mandatory for all banks to reimburse victims in all but exceptional cases, which we think are where customers have been guilty of gross negligence, so that more victims can get their money back. There's going to be new legislation that puts all that into place, and the government is trying to ensure greater consistency in protections for all victims, irrespective of who they bank with. They're also trying to incentivize banks to actually prevent this fraud because it is partly their responsibility.
Okay, so what is this new scheme then, and when's it due to come in?
So the new scheme is intended to come into force in October this year and will apply to payments made after that date. Just as a summary of what we can expect, it's going to involve, first of all, mandatory reimbursement for victims within 5 working days. The cost of reimbursement will be split 50-50 between the sending and receiving banks, and there will be a maximum value of compensation set at £415,000.
All right, so that's mirroring the financial limits on what the Ombudsman can award as compensation, really.
That's right. It's the same financial limit as the Ombudsman Service. So that brings us to the end of today's podcast on APP fraud. If you have any questions for us, please do get in touch at www.collierbristow.com. Thanks very much for joining us, and do look out for our next Collier Bristow podcast.